And while some states are embracing the Second Amendment as a means of protection, other states continue to attack it. Joining me now from Springfield, Virginia, Executive Director of Gun Owners of America, Erich Pratt. Erich, Texas, as of August 1st, it is now legal for people who have proper permitting to carry a firearm on the campus of a community college. So this is moving in the right direction in terms of embracing the Second Amendment. On the other hand, you look at a state like New Jersey, you have lawmakers there now looking at the smart gun technology, which I think most gun owners would agree essentially turns a firearm into a very expensive paperweight. So is this issue becoming more and more a polarizing state issue, that being this issue, the Second Amendment, and protecting the Second Amendment?
Well, Graham, it's good to be with you again. It's polarizing in a few states, but honestly, through most of the country, freedom is growing and expanding. It's exciting that just in the last year, the number of good pro-gun bills over anti-gun bills have been passed at the state level at a rate of 20-1. So you really have, like you were mentioning, Texas, a lot of good laws being passed, and you still have your New Jerseys and Californias and New York and the District of Columbia that are remaining intransigent and don't want to recognize people's right to keep and bear arms.
And we know 8 years of Obama did wonders for gun sales in this country. I believe gun sales are still strong. Barack Obama also did wonders, if you want to call it that, to the D.C. Circuit Court. But out of the D.C. Circuit Court, a rather huge ruling. And it pertains, of course, to the Second Amendment and concealed carry. And part of the ruling was that the law-abiding citizen's right to bear common arms must enable the typical citizen to carry a gun. So if we can translate, step back, and you look at the big picture of this D.C. Circuit Court ruling, this was all about concealed carry and whether the Second Amendment allowed human beings, that would be Americans, to carry a firearm within the District of Columbia.
Yeah, this was a huge ruling. What the D.C. government has told people is that you have to show a good reason to exercise your right to carry. I mean, imagine doing that with any other right. You have to show a good reason to vote, or Graham, you have to show a good reason to air your broadcast. People would go crazy if we interpreted any other right that way. And so thankfully, the panel, the federal court, said absolutely not. That's unconstitutional. Dr. John Lott has done the number crunching, and he said if D.C. was like any other right to carry state where it was easy as long as you're a law-abiding citizen, you can carry a gun, there would be 48,000 people based on the way it is in other states, 48,000 people in the district carrying guns. Instead, there's only 126. And that's because of this good reason requirement. Anytime you have to get permission from a government official to exercise a right, in some places, they're just going to tell you no. In fact, Hawaii has a very similar law, good reason, quote unquote law, and they haven't found a good reason for anybody to carry.
And if you enter the District of Columbia, Erich, you basically, even if you don't live there, let's say, for example, you're a congressman, you essentially give up your Second Amendment rights. But this was, I would consider, so of course, it's a big victory for the Second Amendment, but it's also a razor-close victory. It was 2-1. So do you see this issue coming before the United States Supreme Court in the near future? Because we know that the Heller ruling back in 2008 addressed the issue of whether folks can own a firearm within their home, but this issue goes to owning a firearm and carrying it outside of the home.
Right. Oh, we definitely see this bubbling up to the Supreme Court. And the two things we have going for us, one is the Second Amendment, a great protection of individual liberties, individual rights, and says that that right shall not be infringed. The other thing is the Heller decision, which you mentioned from 2008. That was such an important key landmark decision, really reiterating the right of self-defense and establishing or reestablishing that it was an individual right. This is something that just so pleases us. The fact, back in 2008, USA Today looked at all the briefs that were submitted in the Heller case, and USA Today came to GOA and they said, we want you to write the opposing argument, the opposing editorial. And the reason they said was our brief was the only one which took the position that the Second Amendment invalidates all gun control because of that phrase, the right of the people to keep and bear arms shall not be infringed. And so it's been really exciting to see the DC panel here, the district court, to appeal back to the Heller decision and really focus on two important things. One, it's a pre-existing right. And number two, they said the Second Amendment erects some absolute barriers that no gun law can infringe. And so that's going to be, the Heller decision just remains the gift that keeps on giving.
Well, this Supreme Court had a shot at a similar ruling. It went the other way in California, yes. Ninth Circuit Court of Appeals, and it decided not to take up the case. I think it's probably long overdue that we somehow mesh together Heller and this ruling and establish once and for all the intention of the Second Amendment. It's not to be abridged. It is what it is, the right to keep and bear arms, not necessarily just inside your home. Erich, thanks.